real privilege and honor to be with you and to be part of the Seyfarth team and to share the podium with Perry, who I consider one of the most knowledgeable commentators on class action litigation in the United States. And so thank you for telling us the dates you're going to be reporting on certain things, certainly be reading them. I have a bit of a challenge today, and that's to distill a 900-page book and over 1,400 rulings, and in essence say to the employer community, what does it mean, and what does it show, and what can we expect in the coming year? So in the next 20 to 25 minutes, I'll try to give you a tour of that landscape and the mosaic of all these decisions and rulings and what it may mean for companies, for workers, and the litigation system in which we find ourselves. I thought there were 4 key trends this year, and the first involved an absolute exponential skyrocketing in the value of the top settlements in this space as compared to previous years. We've done the report for 14 years, and I'm either happy or I must admit I've read every class action decision issued by a federal and state court in the last 14 years and followed this space from settlement to settlement throughout the years. And this was far and away, by far, the largest cash take for plaintiffs' lawyers in any year that we have followed this particular area. Breathtaking and remarkable, maybe would describe what occurred. And then I think that one of the things that employers can take away from that environment is they actually did much better in the courthouse in 2017 as compared to 2016. And that the headlines of the plaintiffs winning case after case after case, when one peels back the onion skin and looks at the statistics that we created in terms of cataloging and analyzing these rulings, employers actually did much better in advancing their cases and fracturing and defeating these cases as compared to years past. The most surprising trend was very counterintuitive, and one that I think most people were very surprised in terms of the turnover in the White House and the lack of an impact it had on government enforcement litigation. And in many respects, the first year of the Trump presidency exceeded the litigation totals and case filings in the last year of the Obama administration, a result that no one expected, but I have some predictions on what may occur in 2018. And then the last was the 800-pound gorilla in every courthouse, and that is the decisions by the U.S. Supreme Court. And I have some comments and some slants on some of those cases that Perry mentioned and how they may impact employers in the years to come. So next slide. So this particular slide talks about the comparative analysis of these settlements. And what we do is we track the top 10 largest settlements in areas of concern and significance to employers, and nearly there was $1 billion increase in 2017 to 2016. And this was the first year of what I saw and would call the reversal of what's known as the Walmart effect. Perry mentioned the famous Walmart Stores, Inc. v. Dukes decision in 2011 by Justice Scalia, which raised the standards, made it more difficult for plaintiffs' lawyers to certify their case, which in practical terms made it more difficult for them to monetize those cases into large blockbuster settlements. Yet in 2017, 6 years later, the plaintiffs' bar, in essence, has found a way around that decision and has readily monetized their cases into pretty significant settlements. The other thing and takeaway from this is what I see every day on social media and in the newspaper, and that is the high-profile attention to these multi-million-dollar settlements by the employee union worker advocate community and the business community looking at companies, investors, customers, and what impact that may have on the market share of company. And if one thing is clear, successful prosecution and settlement of these cases at these high numbers begets copycats, and it fuels more litigation. So to the extent that 2017 saw this track record of settlements higher than ever before, I think that lays the groundwork and the positioning of the plaintiffs' bar for 2018 in terms of their goals. So I would expect there's certainly not going to be a slowdown. If anything, there's going to be a speed up in terms of copycats trying to replicate success in this particular area. Next slide. We track settlements in 5 areas: employment discrimination cases, ERISA cases, wage and hour, government enforcement litigation, and what are known as statutory causes of action. And in 2017, the numbers shown in this bar graph were up in every single category except wage and hour. And I don't think any employer can take to heart that, oh, things are trending our way in the wage and hour space. But in essence, across the board, any way you slice it and dice it, the bottom line is that plaintiffs' lawyers have successfully rebooted their strategies to take account of and work around Dukes to file these large cases and monetize them. It reminds me of when Mark Twain was quoted and said, my death has been greatly exaggerated, and the death of class actions perhaps was greatly exaggerated to the extent that companies, employers, defense lawyers said, after Dukes, these cases are going to be smaller, aren't going to be brought, and plaintiffs' lawyers are going to have barriers or impediments to success. The figures in 2017 show just the opposite. So in another space, the securities fraud, directors and officers litigation showed in 2017 an upward trend in most cases that were ever filed. We saw that in the employment space, and other than in government enforcement litigation, I think we're going to see that again in 2018. So I sometimes look at what's going on in the courthouse as a door opening or door closing decision, or conditions are green light or red light for the institution of these sorts of cases. The statistics show we're in a green light zone where these lawyers are going to be filing more of these cases. Next slide. I think one area where people might say, well, wage and hour settlements were down, but if you look at the statistics and you look at the amounts, the last 2 years of the top 10 settlements spiked $1.2 billion. Clearly, plaintiffs' lawyers are filing lots of these cases and making lots of money, and the number one settlement in 2017 could be a showpiece or exhibit one to what's going on in the litigation industry. The Federal Express settlement for $227 million over the misclassification of delivery drivers. FedEx said they were independent contractors, not entitled to overtime. Plaintiff said, no, we are treated as if we are employees, despite the fact we're labeled as independent contractors, and every minute past 40 hours we should be paid overtime. Case settled for clearly a significant sum of money. What this shows is wage and hour cases are the new tort of the day. If you're an employer, this is the number one place where the rubber meets the road in terms of the susceptibility to suit, where the way in which a lawyer classifies people, pays people, more often than not, is going to be the Achilles heel of the corporate suite, where the large bet the company cases are going to be filed. Next slide. Another area we track is what we call other statutory cases. Perry referred to them like TCPA cases, or Fair Credit Reporting Act, or workplace antitrust cases. And here there was more than a fourfold increase in the amounts that they were settled for in 2018 alone. In the month of January, there were 15 workplace antitrust class actions filed against employers for wage compression and wage issues in terms of the way in which they pay or prevent people from leaving a company and going to work for others in the industry. This is not a new area, maybe a sleepy area in the past, but I would look for these numbers again to increase. And so if nothing, the plaintiff's bar is inventive and creative and finds a way. And this is certainly an example where the plaintiff's bar is reaching out into this particular area and spiking the ball and securing quite a bit of success in this particular space. Next slide. Here is the slide for government initiated litigation. In essence, the Department of Labor and the EEOC. And here was the largest increase in any of the areas that we followed, nearly a tenfold increase, despite the fact we had a Republican pro-business president in the White House. My own take is it took so long for the new president to appoint leadership in the Department of Labor and in the EEOC, and the Senate has yet to confirm the two new appointed members of the EEOC, that prior Obama appointees were still in control of the levers and the positions of power in these agencies. There were cases in the pipeline that were both brought and settled, and as a result, you saw in the instance of the EEOC, more cases filed in the month of September of 2017 than in the entirety of the last year of President Obama's presidency. We saw nearly a tenfold increase in the amount of settlements that those agencies took down. I defend EEOC lawsuits throughout the United States, and what I saw, so to speak, in the hinterlands were government-appointed attorneys, knowing there was a change in the leadership, in essence, filing their lawsuits, rushing their lawsuits, being able to do so without having to check with anybody in Washington, D.C., sitting down and asking if the employer wanted to settle the case, not knowing when the plug would be pulled and new leadership would be in charge. And so it was kind of a perfect storm that resulted in more lawsuits and higher settlements than ever before. Entirely a result that surprised everyone, that no one expected. I do believe in 2018, you're going to see that number dip substantially as positions of power that the Trump appointees are in. It's already happening at the Department of Labor with shifts and reversals to positions taken by the Department of Labor. I expect that to occur with the EEOC in the way in which lawsuits are filed and the decision-making process as to which particular employers are sued. And I would expect smaller lawsuits involving smaller groups of employees as opposed to traditional lawsuits brought by the EEOC during the Obama years, where a policy or practice such as how does an employer hire and does it use a criminal background check that every single employee goes through and therefore allegedly discriminates on the basis of their national origin or race. I think you're not going to see those, or if you see them, they're going to be one-offs, not indicative of the entire docket of the EEOC. So in 2018, I would expect this is the area of change. It'll be significantly different from 2018, but I think that the private plaintiffs' bar will fill the void, and to the extent the government lawsuits aren't brought against particular companies, they'll be brought by the private plaintiffs' bar. Next slide. The last area is in employment discrimination, and this also showed a significant increase. And in the fourth quarter of 2017, corporate America entered a brand new era, one that never existed before, with two words. It's called the Me Too era. And everyone is wondering what sort of impact that's going to have on a litigation focus and employment discrimination litigation. We're already defending two, what I would call Me Too class actions. They are cases that probably never would have been brought before the Me Too movement. I may be a little bit old school because I defend them and I fracture them and I don't allow them to be certified. But I think that that is an area where the plaintiff's bar will have to be very, very inventive to secure success. And although headlines in the paper may be very difficult to stomach for some employers, and the piper must be paid in a certain respect or in a certain way, I'm not quite sure, I'm not convinced just yet it's going to be through successful prosecution of class action litigation insofar as sex harassment is concerned. But the plaintiff's bar is game, and I expect that you're going to see those cases, and you're going to see some big cases filed in 2018 as a result of the Me Too movement. Next slide. The second trend, and what I had mentioned, was employers actually did better. And this year, there were 290 workplace class action certification rulings throughout the United States. I think the first one was on January 2, and the last one was on December 29th, the last business day of the year. But of those 290, a little factoid, 3 of them were issued on Sundays. So some of our federal judges also issue decisions on Sundays. But in analyzing these, the bottom line is what we found, and hard to read, but on this particular graphic are statistical breakdowns per circuit. But what it shows is not unlike real estate and buying a home in a nice neighborhood, location is the most important driver with respect to success in certifying these cases and therefore monetizing these cases. If you're on the other side of the V and you're a plaintiff's lawyer and you're looking to secure money for filing these cases. And on the left coast and the right coast, known as the Second Circuit and Ninth Circuit in the San Francisco Bay Area and Manhattan in New York, that is what I have found to be absolute ground zero, where the case law is most favorable for plaintiffs, most deadly for employers, walking into the lion's den, so to speak, in terms of trying to litigate those cases in those particular venues, and that's where plaintiffs do better. In the past, the thinking was the Ninth Circuit was the toughest place to be in San Francisco. There was a saying that a judge there would even certify ham sandwich in appropriate circumstances, but actually this year New York was the best place to be if you were a plaintiff with a win rate of upwards of 95%. But we analyzed them all, and basically what this shows to me is if you're a company doing business either in California or New York, and the issue in the lawsuit is of significance, even though you may do business in many other states, more likely than not, you're going to be sued either in Manhattan or in San Francisco. Next slide. Wage and hour topped all the other filings in terms of the amount of lawsuits that were brought. Right now in the federal system, 90% of all the quote big unquote cases that exist are wage and hour cases. And there's a migration of skilled plaintiffs' lawyers into that space. And the reason why, nothing more scientific than what I see or what I experience or what I've seen over the years, called the stock market investment analogy. And that is, these are low cost investments for a plaintiff's lawyer that result in high return for a minimal amount of work. And so unlike in an ERISA case involving a pension plan or an employment discrimination case involving the application of a policy to a particular protected category, where the ability to certify that case involves hiring a statistician or an expert at a cost of probably $250,000 to $1 million, taking 18 months worth of discovery, running into defense motions about every other week. It's a very difficult area for the plaintiff's bar to convert their case into a class certification order. Conversely, in the wage and hour area, a plaintiff's lawyer can have one client, one person. They sign a declaration, they file their motion, and within 2 months to 6 months with minimal discovery, they can certify a case. Low effort, low investment, high return to flip those certification orders into these settlements, which in 2016 and 2017 totaled $1.2 billion. So it's no mystery to me why the plaintiff's bar is focusing on the wage and hour area, why employers are being sued more in wage and hour class actions than in any other area. This bar graph showed the statistical results of, in essence, plaintiffs win 3 out of 4 wage and hour certification motions they file, and they convert many of those into big settlements. For the employers who are not faint of heart, willing to go through discovery and the expense of dealing with the case, this year did better than in any other year. They decertified 63% of the cases, a jump in 18% over the past year. This was a statistic, at least for us, in following this area for 14 years, that jumped out. And what it says to me is employers are doing a much better job of putting on evidence of their compliance regimes and their compliance activities, and showing that when the judge takes a deep dive to all the evidence, employers can fracture these cases, decertify them, and not have to pay these big blockbuster settlements. So it's difficult to go through the process, but defendants, employers are starting to do much better than they did in years past. Next slide. This showed in this bar graph how plaintiffs did, and in the employment discrimination area, 2 out of 3 cases get certified. In the wage and hour area, 3 out of 4 cases get certified, and about the same in the ERISA area. Decertification, very difficult in the employment discrimination case. Thank you, Laura, for the shout out for how we succeeded 2 weeks ago in decertifying a whopper of a case in New York, but can't bank on that, doesn't happen very often. But in the wage and hour space, it's going to happen nearly 6 out of 10 times. And so that's the area where the plaintiff's bar is focusing. That's the area where most employers are having to defend themselves. And the good news, in light of all of these headlines and all these big settlements, is if you stick with it, employers doing better than in years past. Next slide, please. We talked about the trend. I won't spend a lot of time on it in terms of the pro-Trump White House, but in essence, Mr. Trump may be our president, but he's not in the business of being able to tell an EEOC attorney in Phoenix, Arizona, not to sue an employer in Phoenix, Arizona over a policy and demanding millions of dollars. So there's a disconnect right now between government attorneys who file lawsuits out in the hinterland and file lawsuits in derogation of the ideology espoused by the Trump White House. And so I think what you're going to see in 2018, when Janet Dillon is approved by the United States Senate and takes the reins of power at the EEOC, you'll see a new general counsel of the EEOC will be Republican. You'll see a shift and a pullback of the power from the field to Washington, D.C. about decision-making power, about what lawsuits to bring against what companies over what issues. I think the end result, when we look at all these numbers in January of 2019, that there'll be a significant drop-off in government litigation, both brought by the Department of Labor and the EEOC. Next slide. Perry talked about these cases at the Supreme Court level, and in a very simplistic way. When I litigate these cases and I'm in the courtroom, to me, rulings are either door openers, makes it easier for the plaintiff to get into court, prove their case, and be able to stick in court and not get kicked out of court, or the cases are door closers. Makes it easier for me as a defense lawyer to slam the door to keep the plaintiff from certifying their case or from success. And if it's a door opener, is the door just slightly ajar so that the plaintiff really can't do much of anything? The one EEOC case decided this year was a door opener, but it narrowed the door very tiny, and it basically said if you're challenging the EEOC, you have one shot to do it at the district court level, and it's very difficult to convince a federal judge or an appellate court to overturn it. And the sum result is the EEOC can do bigger, deeper, more robust examinations of employers. And so what we've seen since EEOC versus McLean are requests for the EEOC for show me all the ways that your 1 million people were paid and put it all on a data tape because I'm the government and I say I want it. And the ability to fight that off has become much more difficult as a result of that decision. Microsoft versus Baker was a door closer. It made it more difficult for plaintiffs to appeal certification orders. That's now in the arsenal of most defense lawyers and companies to cut down on the ability of plaintiffs to keep class actions alive. Bristol-Myers, very interesting, but it again allows defendants to chip away at, fracture, and do damage to class actions brought by the plaintiff's bar. Last slide. Perry talked about these cases. I view the Epic case as an epic case. It's going to be the most significant case decided by the Supreme Court since Dukes v. Walmart in 2011. It will either green light and open the door, courthouse doors wide open to plaintiffs bringing these class actions, or it will close the door ever so slightly and make it more difficult if employers heed the decision, help themselves, and craft legal, time-tested workplace arbitration programs. But I've always thought, beware of what you wish for, because the plaintiff's bar will find a workaround. And I don't want to reveal secrets, but what I can see are plaintiff's lawyers sending demand letters saying, I represent 8,000 people. We'd like to arbitrate them together, or one at a time, 8,000. And so the dealing with groups of people with grievances is not going to go away. Maybe the form will change. And so look for the fine language in that decision. My prediction will be 5-4. Not quite sure who's going to win, but certainly, like Mark Twain said, the death of class actions is going to be greatly exaggerated, even if the employers win. So that's a very quick tour of a 900-page book and a lot of rulings, and I hope that kind of demystified some of the things that are in front of us this year.